Introducing the Institution of Surveyors of Kenya live stream and live chat. Do you have a question from any of the following areas? Land survey, valuation, building survey, land administration, engineering survey, estate agency, property management, and geospatial information management. Join the Institution of Surveyors of Kenya live stream and live chat every Friday from 2 p.m. to 4 p.m.
Good afternoon, viewers. I welcome you to the ISK Facebook live chat session. Today being 28th of August 2020. This is a show that is hosted by ISK and it happens every Friday from 2 p.m. to 4 p.m. It mainly deals with land issues. For today, I am your host. My name is Mercy Jamoya, and I do welcome you to share your views, your comments, or questions. More about me: I'm a land administrator by profession. I have been in this field for quite a number of years. My first interaction with land administrator was as a land officer with the Ministry of Lands. I have worked under that and the sector for quite a number of years, grown in ranks and grown in the profession. It is out of that experience that I joined the Institution of Surveyors of Kenya as a member of the Land Management Chapter. In the year 2013, a new institution was put in place to deal with land administration and management matters of public land. That's the National Land Commission. And I, among other people, we joined the National Land Commission to help continue to further the issue of land administration and management. And today, viewers, I am now a member of the National Land Commission as a Director Land Administration. I will be discussing one of the topics that are lined up for the live shows. Today's topic is on how to acquire a land title in our country. This is a very wide topic. We could hold it for quite a number of sessions. 2 hours are not enough. But we can also narrow it, and we are going to narrow it to the key procedures or processes that any member of the public can acquire a title through. There are several known procedures which are by law on how any person can acquire land and acquire a title for that land. These procedures include allocations. This is something every member of the public knows about, that land is allocated in this country. There's also another process under which one can eventually end up getting a title. And this is a process we call a land adjudication process. Beyond that, there's also acquisition of title by transfers. And titles can be acquired through a process of compulsory acquisition. Also, through prescription and transmission. Viewers, those are quite a number of topics. which we cannot handle within the session. So for today's session, we'll just discuss the processes of allocating land adjudication, and transfers, and how those processes end up making an individual, a company, or a group of people acquire title to land. To kick it off, let me generally talk about land in Kenya. Land in Kenya is categorized, and the categories, which are by law, help define the processes one should acquire land and where. By this I mean, we have land which we generally call public land. This is land held by government, and for today it is land that is held either by the national government or the county governments. Under that category of public land, allocations happen because that land, it's held for each and every Kenyan, and each and every Kenyan has an opportunity generally to have land within that category. But again, it is a controlled process because we cannot all scramble to get public land as it is for a purpose, it's held for a purpose. The other category of land is a category of land. In the previous dispensation, we used to call it trust land. Under trust land, this is an area, a block of land spread all over the country where people would acquire their titles through a process of adjudication. This process of adjudication has been discussed in other sessions, and this information can be accessed by getting to the ISK YouTube. So it's another area on getting land, but it falls under that category of land called trust land. But we no longer talk about trust land, we talk about community land, as from the Constitution 2010. We renamed trust land to community land as we are reforming mechanisms of managing land in this country and holding this land. There's also the other now category of land where one can get title to. This category of land, it is called private land as per the law. I want to tell you viewers, private land, it's actually a derivative of processes from the previous categories of land I have talked about. That is the public land and the community land. So if land is determined at the category of public land or at the category of community land through the adjudication process I mentioned, then what it gives out, it's land to a private individual. So private individuals have title to land. If they have title to land, then this leads to the other process we are going to be talking about of transmission. So I hope I am very clear that today we are going to be talking about three processes of getting land. That is allocation, land adjudication, and transmission. And I have given a background against how these processes are laid on this land called land in Kenya. It is land held under three categories. It has been categorized for purposes of then being dealt with to the extent of creating ownership. Having said that, viewers, Let me again now get to each of those three processes. I'll talk a lot about allocation. It's of interest to almost every Kenyan, and I should even say to every Kenyan. Allocation of land, as I said, happens on public land. In the years gone, this public land, we are calling it government land. And then how did it come to be? Yet we had one country. Why did we have public land or government land and trust land, or what we are now calling community land? For ease of reference, so that we may know how land is allocated in this country, let me just put it across to everybody that what is public land? In our understanding, it is all that land in our republic, when we were colonized, was taken up by the colonialists for ownership or for developments of the economy of this republic as they were now governing us. So any piece of land in the country where either there was an office of the former colonialists, or any piece of land that was alienated to the whites by then, it is that land which today we call public land, because that which was taken became government land. That which was not taken was left as the trust lands, the land which was for the natives. So those two categories were derived from that kind of a reaction to our land rights. Now, this public land category was given out to the whites, and the rest of it was set aside for economic development, essentially for urban development. So in most cases today, we talk about public land mainly being dominant in public areas which are urban areas. Before we even get to have your views and comments, people will be asking, don't we have public land in this category of land called community land? Yes, we also do have public land there. And how it happens to be is that trust lands were being managed by the county councils. And the county councils were also growing the economy of the people ordinarily resident in their jurisdiction. So through planning, land was being set aside for urban areas. And any land which was set aside for urban areas became public land. And that public land would be managed alongside the other category of public land held by that time by the president and managed by the Commissioner of Lands. So the laws were put in place that linked trust land set aside for public purpose to public land under the category of Commissioner of Lands, and the authority would be given by law. I may not be remembering whether it's Section 23 of the Trust Land Act that empowered the Commissioner of Lands to administer urban areas on behalf of the county councils. So now, apart from the land in the rural areas that was held by the whites and was surrendered to the Republic of Kenya on attainment of independence, we are going to talk about acquiring a title to land on public land, mainly in the urban areas. Because whatever else is public land in the rural areas, we usually have it alienated through the process of settlement. And settlement creation, settlement schemes, again, were discussed when we had the session on adjudication of land. So we still have that in our YouTube we can always go back there. We refresh ourselves on that. So we'll get into discussing allocating public land to the extent of acquiring a title. It's very interesting that the general understanding of the public is that the document that is issued after one has land is a title. It is a title, and we used to call it a title deed for areas that are agricultural. And so in adjudication, when we get there, or when we refer ourselves to the session that we are ahead, which is in the YouTube, I keep on repeating, we'll be talking about adjudication process leading to a title deed. In urban areas, we actually get leases, because I said this is land set apart from all other categories of land for purposes of enhancing the economy of the country. So this land, it is given under controlled use. And controlled use have many aspects. And hence, there is the law that governs how land should be allocated in urban areas. Allocation of land, as per the laws that are there, and I'll talk about allocation of land in the public areas, has several distinct processes. First of all, there's the process of planning, because land must be assigned its uses if it has actually to be used sustainably, it has to be used productively, and it has to serve its purpose, and it has to be in an organized manner. So the first process of allocating land in the urban areas, of allocating public land category, it is land use planning. So every urban area, it is a requirement of the law that there should be a development plan that assigns land uses for boundary use, and that should never be put aside of every process. And currently the law emphasizes on planning, because it's planning that is going to help every holder of a document called a lease, which in our real language we are calling a title, have a document that has value, because it is a document against the use that has been assigned in planning. Now, after planning, what the law envisages is that that land which is to be allocated should be identifiable. And because the whole of the urban land, it's not allocated in a day. So once we have a plan for the area, which we call a development plan, let's use an example, because I'm here in Nairobi speaking to you this session this afternoon. Let's assume we are talking about Nairobi area, Nairobi city. We expect the underlying document that should determine ownership of land in this Nairobi city to be a development plan for Nairobi area in terms of land use planning. If we are talking of a neighboring township like Junja, just here, or Roiro nearby, we expect a development plan for that urban area. But since land will not be allocated in a day, then when interests are realized for developing land against the uses that it has been assigned, there's something else now we call part development plan. That the same planning process will go back to that bigger plan and pick portions of land that require to be given out for development to applicants, and part development plans will be done. It's against those part development plans that are also showing parcels of land and their intended uses that we say for allocating land, they should again be specific. For them to be specific, there is now the process we call surveying. So I want to get us to get these processes. That the first process is planning. Now we get to the next process of surveying, determining the actual pieces of land on the ground against the plan that has been done. Once that survey has been done, then I'm talking from a broader perspective. The other thing that should happen is the allocation. The allocation will be done, and I'll talk about how then that allocation is done. And after the allocation has been done, against the conditions of allocation, should one accept the land, pay for it, then a lease is done by way of preparing a contract document between the institutions that are managing that land and the beneficiary. That lease is the one which is submitted to the registrar for registration, and people get their certificate of lease, and they go home happy saying they now have a title to land, a lease to land in urban areas. Because the title to land, we are talking about it in other categories of land like adjudication, or when now it's private land arising from that adjudication. So generally, that is the way the allocations should be done in those 4 stages. The question then will be, at what time do we determine an allocation should happen? The process of allocating urban land, it's very well prescribed by law. Indeed, because in this process we are even going to talk about what will happen if these processes were not done and people own land. What will happen? We'll talk about that. But for now, let me just say, if all things were equal, the law prescribes that land in the public of this country of ours should be allocated through public auction. What do I mean by that? Should a county government or the national government have a piece of land that they feel should be made into use, whether it's commercial, industrial, or residential, then the law, and especially the current Land Act 2012, talks about that the county government or the national government, through the National Land Commission, should institute a process of undertaking auction. This process, it's actually the one even which was there under the repealed Government Land Act, the act that managed public land by then, which was being called government land. However, it's a tedious process, and it so happened that it may have been felt by then that that process was not going to be adequate to release land to users for development. So it has never actually taken its momentum as it should. The other process of allocating public land to lead to a lease or a title, it's actually having allocations confined to targeted groups, group of people or group of users, to generally maybe deal with their disadvantaged position or ameliorate their situations. This is to say, like, we may have people who are squatting on public land, and for them to have that land, because it's public land, and every person should have an opportunity of having a piece of public land if it were just to be like a free-for-all, but it's not free-for-all. But should we maybe have people who are squatting on a piece of public land in the urban area? Let's even talk about the areas like Mukuru here in Nairobi. Then we can have land allocated to those people who are sitting on that land, so that we now move them from that disadvantaged position of being called squatters, and they become the owners of that same piece of land. That's a target group. We may also have target groups. We can even have women groups, youth groups, who may identify land in any urban areas, and they may say, then we need to have some land to develop this kind of investment. Then that again, it's a group of targeted land users. And if that land is there, then they are free to apply for it, and it will go through all the processes of planning, surveying, and allocation. The other process of getting allocated land in our public land category, it's by what we'd call public proposals, requests. Any person who feels like being an investor, any person who feels like wanting to advance themselves by advancing the public good by developing a piece of public land can actually apply. So one can apply for a piece of land to undertake industrial development, commercial development, residential development, and all this happens. So individual applications, either for projects or for individual development, are actually encouraged by law. They are provided for. So one only needs to identify a piece of land for whatever use and find out whether that piece of land is available. Then you can apply to the respective institutions that are supposed to help you acquire that land. And again, that process on how to apply, I'll talk about it because it's already prescribed in law. The other way that land can actually be given out by way of allocation, it's actually by tenders. Tender is almost like the auction. A county government or a national government can just have one prime piece of land and call for people to tender for it against the procedures of tendering as they are prescribed in other laws. Again, that is also another way. The other way you can have land allocated to you, it's by exchange. You may have a piece of land somewhere, and you may negotiate to exchange that piece of land with another held by the government. The government can also identify your piece of land, and instead of buying it out from you or acquiring it from you personally, it negotiates with you to have a land exchange, a piece of land from one side of the township to another side of the township, an industrial plot for a residential plot, a commercial plot for maybe a public purpose plot, depending on the needs. So exchange between private individuals and the government also happens. So at the end of the day, you'll be getting allocated land in the public domain through an exchange procedure. But again, all these processes do not seem to be taking care of the common person. So how do people generally also get land without having to go and look for where is a vacant plot for me to apply for it, without waiting for auction, tender processes, or being approached for exchange by the government? It is the interest of the government to release land when it's available to the members of the public for use for development. For this to happen, we have a process we call balloting process or the lotting process. This process entails a process whereby any county government in any urban area will go and look at its development plan, get an area which was zoned for residential use. That area needs to be opened up for use, and it needs to be opened up by allowing members of the public to have the advantage of owning land in that area. So that land will be planned into plots, surveyed, and after that, it will be advertised for allocation to members of the public who will apply and meet the criteria that will be given. And these members of the public will be now the ones who will be called upon when the time comes to ballot for those plots. So that again happens. So when all these processes which are given by law are undertaken, and one happens now to own the plots, this land, it's now owned by conditions of use subject to the planning. And once you fulfill those conditions, then I said that is when the lease will be prepared, and that lease will be submitted to the registrar. It will be registered, and once it's registered, you'll have a certificate of lease. Presently, viewers, the process of allocating land, because it is no longer there, as it were, that any county government would be getting a block of an area zone for commercial, planning it, advertising it, and people being called to ballot. This land, it's no longer common. In fact, we are in short of public land. Even for key investments, we are short of that land. And this, because of all the previous allocations that happened before the new constitutions came into place. And now, the current laws are a little bit restrictive on how to allocate land. And they have restricted themselves to just those 4 procedures. And I can't call them 4. It's like there are 5. There are 5. The tender, the auction, the exchange, the process of targeted groups, and then the process of requests and the drawing of lots. Those processes are in a way that every allocation ought to be an allocation that is a known fact that is happening. So there, the law, this is what it's providing currently. If, as a person, you identify a piece of land that you feel you are capable of developing against the planning that has been done, you are supposed, as a member of the public, to apply for that land if it falls within the category of land that is under the county government. And most of allocatable land, as per the definition of land in our constitution today, most of land that is allocatable to members of the public for whatever developments, it's actually more or less under the county government. One is now supposed to go and apply for that land through the county government minister in charge of land. Once that application is forwarded, then that would be communicated. If the county government feels that land is allocatable, that will be communicated to the National Land Commission for the National Land Commission to check whether actually that land is actually in the status of being allocatable, because the law today tells us which lands cannot be allocated. We cannot allocate land that is not ecologically suitable, We cannot allocate land that is claimed by other people. We cannot allocate land that is not planned for the use that is supposed to be used. We cannot allocate land which is not environmentally suitable. So there are things that ought to be checked. Should we find that there is no problem, there is no overlap, there is no other person on that land, it is ecologically suitable, that it's available in all manner, then we tell the county government we have no objection with the processes of allocation being put into motion. And with that, then the county government may go ahead and call for planning. And now we know that the county governments have been empowered to undertake planning. They are planning authority. So that land will be planned. And the planning process, as I said, is the first action towards allocating land. That planning process is supposed to be so participatory that each and every person is supposed to know that there's a piece of land which is being planned, which has been planned for allocation. It may not be saying to who, but at least people should be knowing, so that if there's other issues that the members of the public should have, then at that planning level, then that can be addressed. Should that land be planned successfully, then that request will be sent to the commission for further processing. Here, there's a disjoint in procedures. The law demands that before that allocation has been done, then after planning, survey should automatically be done. But again, we are trying to harmonize our laws so that they can systematically flow without disjoints. Currently, a survey to each and every request can only be handled by a private surveyor. That means it is a cost to a person who has the land, or it is a cost to the county government that wants to allocate. It has not come out clearly at what time the county government will be undertaking a survey for a person it wants to allocate land. And if that person should actually meet the cost of surveying to be able to go to the other stages of allocation. Situations are here too. Should the member of the public who had applied for land be told to undertake the survey so that the other stages can follow, and at the other stages it turns out that that land cannot be allocated, then how will that person be refunded the cost that one underwent the survey? Should the county government undertake that survey and then recommend that person for allocation, and then the allocation does not go through, then how will it undertake the auditing of the expenses that it has already incurred? Or take it backwards, in the planning for finances for expenditure, should a county government always set aside monies that should be for survey for individual applications? So we are having the problems on when survey should be done before an allocation. And so for today, once the plan has been done, that plan is recommended to the National Land Commission to allocate before even survey has been done. And now once it's with the commission again looks at it, and as it looks at it, there are things which are considered. In law, we'll check again the processes of recommendation for this allocation. What was looked into? The law demands that should that allocation be of substantive size or value, the county government assembly should actually have approved that allocation. So we'll check if it's not that substantive and that has also been defined in the laws, then we will not be demanding the county assembly's approval. Should it be, then there will be a county assembly's approval. We'll actually check whether the process of planning actually met the conditionalities of the planning law. We'll actually check whether there are objections. If there are none, then we'll again do a second advertisement or gazettement. We will again notify the general public that this piece of land, which was applied to the county government, was planned, it's now getting allocated. That is the second public participation on a process of allocation. If there are no objections, then we are going to undertake the allocation. We'll issue the allotment letter with the conditionalities of use and management. And those conditionalities of use and management are actually the ones which give the functions of the commission under Article 67 that says that public land shall be managed by the National Land Commission on behalf of the county and the national government. We have allocated this land for a particular use, and that particular use is prescribed how it should be owned, used, or transacted upon. So those conditions are the conditions we manage over time. In the allocation, we were actually administering, determining. We were in the process of determining lights. Once those lights have been determined, we'll be left now to manage those conditions. And so we issue you a letter of allotment. We have determined those lights should now belong to Mercy, and then Mercy should use this land in this manner, should be paying rent in this way, should be paying rates to so-and-so. Should she wish to do any development, the building plans should be approved at around this time, the lease should be in place at around this time. So all those conditionalities are managed through and through the period of the lease. Leases are now given for 99 years. They can be given for less depending on the use of the land, but can never be given for more than 99 years. And that allotment letter, one is supposed to make payment. Once you make payment, then that is the time now currently the survey is undertaken. And once the survey has been undertaken, we'll get now the survey records, prepare a lease, and that lease will now be executed between the beneficiary and the institution, that is the institution of the National Land Commission, and will now be forwarded to the registrars to register. I know by this time there could be comments or question marks which are being put by people, because I know members of the public know that the leases are being prepared by the ministry and being registered. That's a topic of another day when we are dealing with institutional mandates. But currently the law and the procedure should be that an allocation process should end at the lease, because the lease is actually that contract agreement that is entered by the plot owner, who is the lessee, and the lessor, who is the county government, whose function is being undertaken by the National Land Commission. So that is how we actually get lease or title to land of the urban land, which is land under the category of public land ownership. I am hoping that I have tackled the process of allocating. There is allocation which is not for urban use. This allocation could be for agricultural use. And it happens for all those remnants of land in the White Highlands, because that's where we have the public land, which have not been declared settlement schemes. And there are still pockets of land under government land for agricultural use. Nothing stops that land from being allocated for agricultural use to individuals, and the government can determine whether to give you a lease of 99 years for agricultural use or even to give you a freehold title. So again, that process is there. It used to be applied as a category of land, of public land. Wherever it falls, it will always be surveyed. So you just have to identify it, apply for it through the county government. The processes will be undertaken and it will be given out for agricultural use. However, currently, most of the public land in the rural areas, we as the National Land Commission, we as the national government, we prefer having them declared as settlement schemes to help members of the public who are landless at least acquire land. So that is what happens. Now, having talked about allocations, the other process is land adjudication for today's topic. And I earlier said, and I still welcome you to forward your comments, your questions, and your views. And with that, I still remind you that we had a session on land adjudication. And because I'm not going to visit it, I know currently the issues that are about title to land after the process of adjudication has been undertaken are issues that have got to do with succession. Because adjudication in this country started from 1958 on the former trust lands, now community lands. And it is now land held in the register by the people who were adjudicated through the process that were taken through. But now much of that land, it's actually being used by third generations, grandchildren in most cases. And these people are asking, how do we get our titles? I just want to say, this is the topic that we'll be discussing in the next session when we'll be talking about transmissions, because it's a process of succession, and that is what is covered under transmission. So viewers, let me not talk too much about a land adjudication process towards acquiring a title in this republic. But then there's the other subtitle of our topic, and this is about transfers. You know, generally transfers is about land market. It's about land sales. There's nothing much about it. It is just that. And when we started, I talked about the three categories of land. I talked about public land, community land, and private land. And I said private land is a derivative of the processes of allocating land or adjudicating or settling people. Now, once people have that private land, the only other way land is distributed in this country, it's by land transfers. And we are all aware about it. It is happening by people collecting themselves and calling themselves land buying companies, and they are buying privately held lands, and those lands are being subdivided and transfers are happening. Transfers by way of sale are also happening in the urban areas. The beneficiaries of that process of allocation to commemorate their circumstances are selling plots in the urban areas. The beneficiaries of those allocations who put up residential units, whether they are apartments, whether they are bungalows, whether they are one-unit residentials, they are selling them. So the only way private land actually happens to give title to another party, it is by land transfers. What we need to be clear about, it's about the authenticity of that title that has to be transferred. And at this particular time, viewers, let me say this. A title in this country, it is as good as its process, because every title has a root. And we have said it. It is either you are allocated, you are settled, or you are adjudicated. your rights were adjudicated. So every title has a root. That root is governed by a process of law. And the process of law defines that process of adjudication to the extent of giving you a good title that can be protected by the state. It gives the process of allocating to the extent of giving you that title that can be protected by the state. It also, that law defines the institutions that should undertake that process. And this is why I'm saying a title is as good as its process. So when there is a private title that can be transferred to a person, it is the honors of the person who is getting it to get to know whether that land as actually was acquired in the right way. Because there's a title, yours is just to do due diligence. So in terms of getting a title arising from the processes of adjudication or the processes of allocation, a third level of it or a second level of it, it is the transfer that one has to be key on how that title was acquired, on the root of that title. And the other third thing I always caution people about, it is that every title in this country has a history. And because it has a history, we are talking about every title has information on it. So there's what we call the importance of information on land titles in this country. And this information will be talking about how land has been acquired, how land has been held, and how that land should be used. So in terms of transfers, one needs to know which title am I acquiring. If it's a lease, then one needs to know that the process under which this title was acquired, it's actually tied by law. The use for this land, it's actually defined, so that you don't end up buying a piece of land for industrial use because you have found a factory or a workshop on the ground. And yet this use is actually superimposed on an area zoned for residential. So we are talking about acquiring a title by transfer, but a good title. So you need to do due diligence. If it's in the rural areas, kindly just need to know how this title is. And for you to know, the government is good enough to have actually put in place a process for managing transactions of land acquired through the process of adjudication, to the extent that they are private, and because they are private, then they can actually enter into the land market through transfers. And which is this process am I talking about? It's the process of acquiring the consent of the land control boards. That process, viewers, it is very key in land transfers, in acquiring a good title. However, Kenyans have this way of trying to shortcut each and every process. I actually hear people talking about, what do we call it these days? Special boards. Well, as a land administrator, as a profession, in a professional body, I want to state that that is not provided for in law. And if we're just doing what is supposed to be done, there's nothing that should be a delay in transfers of land. It is so much prescribed that boards are supposed to be there every particular time of the month, twice in a month, once in a month, and people just need to know. And if you want to have a good title, and especially because transfers of agricultural lands are actually transfers of land whose history, and I'm talking about every piece of land has history, which history has actually arisen from a process of adjudication. And we are talking about adjudication. We are talking about family lands. And if we are talking about family lands have got issues. So you don't just jump to a special board, because you may be buying a title that is contested by a family and you may lose it. So all my request is that the processes that are put there by law, let us follow them. Let us actually respect this process of the land control boards, because there's an act of parliament that governs that, and it has a purpose. It's actually supposed to caution buyers of land. In the urban areas, there's what is called a consent as a condition of the lease that you have been given. The lease condition, or when the condition says, thou shalt not transfer or transact on this piece of land without the consent of the lessor. And so that consent is particularly necessary so that you don't buy land that is encumbered, so that you don't buy land that has got development issues, that actually has got debts with the government, that maybe it's encroaching on a road. The developer or the person went and surveyed into other people's land or into a road reserve, or it's even a title or a lease acquired and procedurally. So that is why it is necessary to have the consent. And I'm saying this knowing that there are so many changes in law, all for a good purpose, to enhance especially the land market. And I know the business, I don't know whether we are calling it the Business Act, has been amended, and in the amendment there is the tweaking a little bit to enhance land transactions in terms of land transfers, where it's saying that today for one to transfer one piece of land, one does not need the consent. I will not get into that, only to caution people that the conditions of the lease are still there, and if two parties are undertaking a transfer of land, then even though the private holder of the land is not conditioned by the amendments of the Business Transactions Act, I don't know whether I'm naming it the way it should be named, it's not conditions to get a consent from the county government, from the national government, Ministry of Lands, or from the National Land Commission before they sell that piece of land. I still insist that it's upon the buyer, the person who is getting this transfer, to be able to get into good arrangement with the person who is selling, to first of all know that if the conditions of the lease were to be revisited, there is no abuse of those conditions by the person who is transferring to you. You also need then to agree on the rates and the rents, all the dues or the debts that are not paid. So this is all the precautions that we need to undertake. For members of ISK, this actually just falls within the domain of us as professionals when we are doing estate management, when we are just undertaking conveyancing. So this afternoon, I would want to say that we have, in a short way, dealt with issues of acquiring title to land by way of allocation, shortly by way of adjudication, and by way of transfers. And I have said transfers are just about the dynamics of the land market in our republic, and this means that transfers always are happening where there's already a first right, the land is private, and all that it needs is for somebody to be very cautious about the processes under which land transfers are undertaken, and this is just about undertaking due diligence on land held by any leaseholder, or undertaking due diligence by way of adhering to the processes of the acquisition of the consent through the land control boards. I hope viewers, until we meet in the second session, that I have given the basics. The rest will be tackled by way of the questions and the comments that will come across, and please set them as they are. Don't even try to smarten them. Once they are sent, we are actually going to make sense of them and respond to you. I wish you a good afternoon, and I hope that we'll be together and even be more than we are today in our next session. And we shall continue as ISK having these sessions. Even if need be, we shall have repeats if need be. Thank you so much.
Introducing the Institution of Surveyors of Kenya live stream and live chat. Do you have a question from any of the following areas? Land survey, valuation, building survey, land administration, engineering survey, estate agency, property management, and geospatial information management. Join the Institution of Surveyors of Kenya live stream and live chat every Friday from 2 p.m. to 4 p.m.